My name is Keith Bybee, and I direct the Institute for the Study of Judiciary, Politics, and Media, which co-organizes this lecture series with the Tully Free Speech Center, which is directed by Mr. McHandsome, Professor McDreamy, Roy Gutterman, seated to my right. As those of you who attend this lecture series know, our goal is to bring distinguished individuals to campus who address issues that are under the broad umbrella of law, politics, and the media. And today we are fortunate enough to have Nan Aron. Nan Aron is the president and executive director of the Alliance for Justice, an organization that has been around since the late 1970s when Nan Aron created it. She has, since that time, been a leading voice in public interest law. Alliance for Justice does a variety of things. One of the things that they do, and they have a high profile for doing, is they participate in the judicial selection process at the federal level. Virtually any time that there is some coverage of opening or nomination or confirmation for the lower federal courts or the circuit courts or the Supreme Court, you'll find Alliance for Justice and Nan Aron mentioned. They are active in this area, and Nan has a great deal of experience with the politics of judicial selection. That is indeed the title of her lecture this afternoon, Politics of Judicial Selection. Before I welcome Nan Aron to the podium, let me just remind you of how we proceed. Nan will speak for about 30 minutes, and then we will have Q&A with the audience. We anticipate a lively discussion. At 5 o'clock, we will break for reception right here in this room, which is an opportunity for continued conversation with one another and with our speaker. Without further ado, please join me in welcoming Nan Aron.
Well, it's a treat to be here and to have spent a day and a half. I've gotten to know some of the students, which has been fun. And Keith, you do fabulous work. So some of my old friends, Arlene Cantor here. Arlene and I worked together at Georgetown Law School just about 40 years ago. So I'm here to talk about judicial selection, an issue that's near and dear to my heart. Alliance for Justice has been focused on judges and who becomes a judge and confirmations actually since the late 1970s when Ronald Reagan became president. But I want to start out first with a little bit of a story. And that is when I graduated from law school, I moved to Washington, D.C., and I went to practice law in an agency because federal agencies offered law graduates then, as they do now, a wonderful opportunity to get into court. I was also rather a troublemaker in college and law school, so I wasn't particularly interested in law firms. More interested in government work, civil rights work, and I took a job at the EEOC. And within a few months of being at the EEOC, I was asked to file a motion to intervene in a huge case in Detroit, Michigan, which was challenging the employment policies and practices of a corporation named Hewlett-Packard. It just so happened that Hewlett-Packard wasn't promoting or hiring in great numbers either women or people of color. And our lawsuit challenged in a Detroit district court Hewlett-Packard's discriminatory hiring and promotion practices of the Midwest region. And I remember I was asked to argue before a judge a motion to intervene. And like all new lawyers, I must have written my brief 15 or 16 times. I must have rehearsed my argument 10 times more than that. And I also looked up who I was appearing before, and this was a judge named Charlie Joyner, district court judge. Any of you from Detroit? A Nixon appointee. And I thought to myself, Nixon appointee, conservative, whoa, this is going to be a hard argument. So, day of argument, I went, I did my thing, I was prepared, I argued, went back to the office, and then, like all lawyers with big litigation, you kind of wait and wait and wait. So, I'll come back to that in a minute. But today's topic talks about the politics of judicial nominations and confirmations. And the question is, are the politics of judicial nominations or confirmations a new thing, or have they been around a long, long time? In fact, at our lunch today, one of the students raised that question. And a couple things about the politics of judicial confirmations. One, I don't need to tell anyone here who's at law school or the Maxwell School or the Institute, but judges are pretty powerful players in our democracy. They make decisions that affect every aspect of our lives, from the air we breathe to the water we drink to whether our workplaces are safe, whether as a woman or person of color you can get promoted in the workplace. Federal court judges decide critically important issues. Interestingly, in a little digression, every 2 years at Alliance for Justice, we do polling and focus groups about the courts, and we present our results to typically senators who are interested in knowing how to talk about judges, and sometimes if there's a Democrat in the White House, we'll share our polling results with the President's office and the White House counsel. And what is so depressing is when you get a group of people, 35 people usually form a focus group, and you ask them 2 questions. One, how many justices are there on the Supreme Court? And if you're lucky, maybe one person in that room knows how many justices there are on the Supreme Court. And then you ask a question, which is, can you name any justices who are on the Supreme Court? If you're a person of my age, 20s, not really, in your 50s, 60s, someone will say Clarence Thomas, because many of us and some of your parents probably were riveted by watching the Clarence Thomas hearings. But other than that, most Americans have no idea who sits on the court or how many justices there are. And it's a little bit depressing to find that out every 2 years, but nevertheless, given the important role they play, it's quite startling. 2, so yes, judges are powerful, and that thought is certainly ever present in the minds of many, many Republicans in the United States Senate, and unfortunately hasn't yet become as important as it should to Democrats in the United States Senate. 2, the whole system of nominations and confirmations in and of itself is political, and it always has been. Some people say it only became political when Robert Bork in 1987 was up for Supreme Court. But the fact of the matter is, if you go back to George Washington's first nominee to the Supreme Court, that person failed because the Senate would not confirm Washington's nominee. The fact of the matter is, our Constitution sets out that the president nominates, but actually, the president just gets a chance to put his person on the federal bench, it's up to the Senate to confirm. And therefore, you've got this inherent tension, which makes the whole process political, and which has been political since the beginning. Up until a few years ago, 1 out of every 5 nominees to the Supreme Court didn't make it. So, and that's over time. So that gives you a sense of the politics of confirmations. What else do I have? The other thing about judges and justices that I know you all know is that unlike state court judges and justices, federal court judges serve for life, which means that some of the justices are on the bench long after the presidents who appointed them are in the White House. William Rehnquist, I think, was chief and an associate justice during the terms of 7 different presidents. Stevens served through 8 or 9 terms of different presidents. So in fact, judges and justices, because of life tenure, have incredible hold over us, the American public, and really our democracy. So I think that's part of the context in which this discussion will take place. But I'd like to start this story with really what happened in the year 1954. We all know what decision came down for the Supreme Court in 1954. Thank you. Brown versus Board of Education was decided. That was, not only in one of the most important landmark cases of American history, but it was a galvanizing moment for people in this country who were furious with the court's opinion. And in fact, it was the first time in our history that we actually saw people, principally in the South, put bumper stickers on their cars saying impeach Earl Warren. It led to a beginning of a movement of people on the right who began to focus like a laser on courts and decisions in the Supreme Court. And then in the 1970s, we had another landmark case, Roe versus Wade. And that was also a galvanizing moment for individuals, particularly the right-wing base of the Republican Party, who detested Roe versus Wade, and joined their colleagues who had been growing. The numbers had been growing over the years, and you had, in the 1970s, a pretty significant constituency of Americans who really cared about who became a judge or justice. With the presidency of Ronald Reagan in 1980, something new happened, and that was you had a president who, for the first 4 years of his term, tried to get the United States Congress to do things like dismantle the Legal Services Corporation. And Congress in those days, actually led by some Republicans in the House of Representatives, said to Ronald Reagan, we're not going to do that. We are not going to eliminate the Legal Services Corporation. He then sought to block the reenactment of the Voting Rights Act. And again, Republicans led an effort in the House of Representatives, assisted by Democrats, and said to Ronald Reagan, we're not going to let you do that. He then tried to legislate court stripping, which would have removed certain cases from the jurisdiction of the federal courts, desegregation cases, affirmative action cases, reproductive rights cases, and again, Congress said no. So when he ran for his second term, he said, whoa, I haven't been able to get my program through Congress. The only place I can really turn now is to the courts. And if I want to change the law, what I need to do is change the judges. And he did something that was unprecedented in American history. He actually ran on a platform that called for the appointment of judges who were sympathetic to school prayer, who were opposed to abortion, affirmative action, and he won on that platform. This was his second term, so it wasn't a surprise that he won, but the fact that he ran on that platform gave him a lot of new energy to come up with what I refer to as a court-packing program that essentially changed the face of the judiciary. Many of his judges that went to the courts of appeal were members of the Federalist Society. Every judge that was chosen for a Court of Appeals seat, and Court of Appeals seat judges, you think of the Supreme Court as the most powerful court, which it is symbolically. But the fact of the matter is the Supreme Court only hears about 70 or 80 cases a year, down from about 150 when Warren Burger was Chief Justice. So it's these courts of appeals judges who were really incredibly influential over the law. Every single one of Ronald Reagan's circuit court judges were chosen. Yes, most of them were clearly smart, clearly had excellent analytical skills, but they were also chosen because of an adherence on their part to a litmus test. And it was interesting. I was taking the plane down yesterday, plane up from Washington, and there was an obituary of a judge from the Second Circuit Court of Appeals, man by the name of Roger Minor, whose memorial services today. And I do generally read obituaries of judges out of interest, but this one was fascinating because in it contains a story which goes back to 1987, when the Republicans in the United States Senate are beginning to see that Robert Bork is not going to make it through confirmation. He was too right-wing. His views were too hostile to all the women's rights, civil rights, consumer environmental protection. And one day, a member of the Senate Judiciary Committee calls up Roger Minor. He was at home. He was a district court judge at that point. And we know the story because the storyteller is actually Roger Minor's wife. And she hears this phone call from another room. And she hears her husband say to the senator, he's clearly asked the question as to what Roger Minor's views are on abortion, which was a routine question asked by the Reagan administration. And she hears her husband say to the senator, I decide each case on the merits. The wife, desperate for her husband to get a seat on the Supreme Court. I mean, which spouse wouldn't be desperate? And boy, do I have stories about spouses in this regard. But she yells into him, tell the senator you're opposed to abortion. And Roger Minor doesn't do that. So I think the wife loved to tell the story because he was that close to getting a seat on the Supreme Court. But he simply wouldn't give up his integrity to tell the senator exactly what he wanted to hear. But those were the kinds of routine questions that used to be asked. Well, so we had an enormous push by Ronald Reagan. We saw an acceleration of that push by George Bush Sr. Actually, when George Bush was elected, he really didn't care much about judges or justices. It wasn't of interest to him. He wasn't a particularly, this is Senior, ideological guy. And I don't know if any of you remember who his first nominee to the Supreme Court was. A guy from New Hampshire named David Souter. And of course, David Souter was introduced by the White House as someone who was really not who he was. But the fact is some of Souter's opinions became released. People were furious with George Bush that he had named someone who wasn't a diehard ideological conservative. So all of a sudden, George Bush had to do a pivot, and remember who his second nominee was to the Supreme Court? Clarence Thomas, who, of course, he introduced to the nation as the most qualified candidate in America for the Supreme Court. I should just say parenthetically, it was the only time George Bush or anyone ever referred to Clarence Thomas as the best qualified candidate for the Supreme Court. The next day, so much pressure was placed on the White House, even by Republicans, to say, you can't say that about Clarence Thomas. But so what was started by Reagan, accelerated by George Bush, because after Thomas, most of his nominations were pretty ideological, was this hold over the judiciary was really cemented by George Bush Jr. We saw the confirmations of two incredibly ideological Supreme Court justices, Sam Alito and John Roberts. And I would say to you that despite the fact that John Roberts razzle-dazzled those senators on the Senate Judiciary Committee by batting his beautiful baby blue eyes and being able to answer every single one of their questions, I'd say magnificently. He really was probably the best performance I've ever seen by any candidate for the Supreme Court. I would say he's probably our most dangerous Supreme Court justice of all time, given the fact that, and any of you who care to debate, I would be happy to do it. But I would say this guy knows exactly where he's going. He knows exactly how to take the court with him. And I think he's so agile and so persuasive that he's been able to convince the fence sitter on the court, Anthony Kennedy, to pretty much tack his way in most of the cases. So we had, right when Obama comes into office, a bench that is clearly dominated, and to me it's less important whether they're Democrats or Republicans. What's more important is you got justices and judges on the bench that are overwhelming, that have been chosen overwhelmingly by their support, sympathy for a certain litmus test that has been used by Republicans. As you all know, Obama and Clinton before him didn't make judgeships the priority that Republican presidents have made them. Both presidents have named some pretty good Supreme Court justices. Clinton's were Breyer and Ginsburg. In fact, a lot of business interests called on the Senate to defeat Stephen Breyer because of his pro-business dealings when he was in the Senate Judiciary Committee. Obama's two appointees are one, your own Sonia Sotomayor from the Second Circuit Court of Appeals, and I should just tell you that a lot of wonderful people in this state had a lot to do with Sotomayor going to the Supreme Court. And the other is Elena Kagan, and I think both are quite spectacular appointees on the Supreme Court. There is pretty much a war going on in the Senate at the moment. Obama has only had 126 of his nominees confirmed, compared to 40 more by Bush, and actually 40 more by President Clinton. There are 20 nominees now in the United States Senate who Republicans are blocking a vote on. And what is unprecedented, and I can say unprecedented, is for the first time in this Senate, we've got filibusters called on almost every single judge by Republican senators. And what's unprecedented is that almost all the 20 who are on the Senate floor have been supported by Republican senators. So we've never had a situation in our Senate where a party would be blocking the confirmations of people they've actually supported. It's quite amazing. But this is an election year. So during the election years, which take place the fourth year of every presidential term, you begin to see the window close on judges being confirmed. And Republicans are now saying the window has to start closing. The Obama administration has now kind of seen that, whoa, we better step up and move and be a lot more aggressive on this. And all of a sudden you're seeing an Obama White House and White House counsel that's trying to push the Senate. You've got Harry Reid for the first time pushing on judicial nominations. So it remains to be seen what's going to happen at the end of the Clinton administration. 61 nominees were prevented from having a vote. That's a lot. 61 nominees. When George Bush came into office, within 3 weeks, he had names for every single one of those 61 seats, plus other vacancies that had developed over the ensuing months. Which means that what's really happening is Republicans trying to keep open as many seats as they possibly can, with the hope that a Republican president, if elected, would come in and fill them. So that's kind of what we're seeing this year. We have already heard some discussion by candidates about the Supreme Court and judicial selection. We heard Newt Gingrich talk about his desire to impeach certain judges whose decisions he disagrees with. We've heard Newt Gingrich talk about subpoenaing certain judges before the House of Representatives to question them about cases that they don't like. We know that Mitt Romney has assembled a committee of, quote, experts to advise him on his judicial selection were he to become president. He recently named Robert Bork to chair that august committee of people. Rick Perry, when he was running, talked a lot about judges and judicial nominations. From the president, we haven't heard much, which is pretty typical in an election year. You'll hear a lot from the Republican candidate, when there is one, about judicial selection. You'll hear a lot from senatorial candidates about judicial selection. And the reason you'll hear them talk about it is because they know, given the history of the court, going back to 1954, that this is an issue that galvanizes the right-wing base of the Republican Party. And they'll talk about it a lot. Senatorial candidates are going to talk about it, and whoever the presidential candidate is going to talk about it. And of course they're going to talk about, as George Bush did, we will appoint nominees who interpret the law, not make the law. That was George Bush's favorite motto. I don't think you'll hear John Roberts' favorite phrase, we're just looking for umpires who will call balls and strikes. I think after the decision that was handed down, the Citizens United case, it's no longer viewed as a court that is simply one that's making a court of independent justices making decisions. I think certainly many people who now study the court accept the fact that these are individuals with very strong political agendas making political decisions. So, to close, so I'm back at the EEOC, and about 10 months later, I get a call from Charlie Joyner's chambers saying, the judge has made his decision. And so I race to the phone, and his assistant tells me that Charlie Joyner has indeed decided the case, and he's granted our motion to intervene not only for a regional class action case, but for a nationwide class action case of women throughout the country and people of color. And I tell that story because in those years, in the 1973-74, you could walk into, as a law graduate, almost any courtroom in the country. And you knew when you walked in that you had a fair shake. You knew walking in that perhaps that judge wasn't someone who had made up his or her mind before you walked in that room. You knew that if you described the facts in a case, you talked about the law, you had the opportunity that you have nowhere else to help convince a really neutral person of the merits of your case. Today, you walk into any court of appeals in the country, and you know, as a new lawyer, and I still want you to prepare your arguments, but you know walking in, once you know who the three judges are on your panel, pretty much once you know who your district court judge is, you know what the result's going to be. And that's because of years and decades of court packing by Republican presidents. And there is something that law students and that students can do about this. So few people understand what courts do and how important judges are. I hope you'll all look on our website. We love to have students help us with research about nominees, both Democratically appointed nominees as well as Republican appointed nominees. When there are fights, we rely on law students to help out. We rely on the research that students produce, and law teachers, and I know some of you are here, can also be incredibly important, and I should say persuasive to members of Congress. So I hope you'll work with us, and I thank you all for coming, and look forward to your questions or comments or arguments or whatever. So thank you very much. And any of you from the Federal Society, I should just tell you, I was pleased that there were some members of the Federal Society yesterday at the film we did on ethics. You will be happy to know that over a third of George Bush Jr.'s candidates or judges to the courts of appeals were members of the Federal Society. That's quite a startling number. I can count on the fingers of one hand the number of Obama judges on the circuit courts, by contrast, who were members of the American Constitution Society. So that kind of gives you a sense of the power dynamics on this issue. I should also tell you that the vast majority of President Obama's judges were previously state court judges, prosecutors, U.S. attorneys, or corporate lawyers. Only one of his nominees, only one, ever worked in a public interest law firm. And that guy got raked over the coals when he was up for confirmation, but he was confirmed. President Clinton's first candidate for a district court seat. This is for those of you who think, oh, the Democrats do the same as Republicans. It blew my mind. Clinton, maybe not his first, but one of his first appointees to a district court was someone with a very well-known reputation for being anti-choice. So, go figure. Democrats deal with judgeships very differently from Republicans. And I would say for my progressive friends here, that until we build a constituency the same way Republicans have for this issue, until we build a constituency, it will continue to be an uphill battle for us to get to what I would say reassert some balance on the federal courts. But in any event, enough from me. Any of you have questions?
Yes. I was just a little bit curious. So you said that Reagan kind of started this flow of judge packing and whatnot. I was just interested in what your view on Carter's. I mean, Carter appointed almost the entire Ninth Circuit and the Fifth Circuit as well. And I was just kind of wondering if you could kind of address that and compare that to what Reagan did. I know Reagan appointed more judges than anybody. I mean, Clinton, I think, was only a few behind him, but I was just kind of curious if you could kind of compare the two.
Well, remind me who. I know Carter appointed Steve Reinhardt, who was in the news last week because of his decision on Prop 8. But Carter made, for the first time in history, he did something that was quite interesting. He did two things that were interesting. One is he made diversity the hallmark of his judicial selection. He wasn't really so interested in ideology, but he was interested. Well, he wasn't interested, but groups really pushed him to put women on the courts for the first time and people of color. He's really the first president that ever did that. The other thing he did was he set out an executive order calling for the establishment of commissions in each of the circuits where, circuit courts exist, to conduct what's known as merit selection of judges. And so New York, for instance, both your senators, Gillibrand and Schumer, have merit selection panels. You can't get to the district court here in New York. Any of the western, eastern, southern, is there a northern district? Is this the northern? Thank you. Northern district, without going through one of the panels either by Gillibrand or Schumer. So actually, Carter had a pretty interesting contribution to make, but I wouldn't say his judges were particularly ideological. In fact, he put Ruth Ginsburg on the D.C. Circuit. You want to know something interesting? When she was up for Supreme Court Justice, she was appointed by Bill Clinton. Her record on the D.C. Circuit mirrored Robert Bork's closer than any other judge on that circuit. She was a conservative judge on the D.C. Circuit. He wasn't so concerned about ideology as he was diversity. Yeah.
You were talking earlier about how the conservatives clearly have a direction, a legal agenda, if you will, which is why they can get a constituent behind them. What is the progressive or the moderate's legal agenda? What is the soundbite that would build that constituency?
If I knew it, I would be a genius. Every 2 years we go about figuring that out. So when Obama was running for president, we came up with this very pithy, beautiful phrase. We want judges who abide by, who are committed to core constitutional values. Not quite the great, quote that you want. It was interesting to see that the president used commitment to core constitutional values, but of course the Tea Party members say they're committed to core constitutional values. So we have been, for the past couple years, given the recent trend by the Supreme Court, and I think we have a corporations professor in this. You teach corporate law? You may not be happy with this. But we have, given the number of decisions rendered by the Supreme Court that rule in favor of big business, the Exxon Valdez case, the Lilly Ledbetter case, the Walmart case, AT&T versus Concepcion case, Citizens United, and a whole host of others. We have begun to talk about this court as one that is referred sweetly by us as the 1% court. The court that has a political agenda in favor of big business at the expense of everyday Americans. And we have come up with that theme really based on the huge numbers of Supreme Court decisions that have ruled in favor of big business. I don't know that that's going to be earth-shattering either, and I would hesitate to think that the White House is going to pick up that language. But nevertheless, it pretty much, we believe, reflects the court's decision-making these days and its propensity to rule for big corporations. Yeah.
It's funny that you mentioned the 1%. Earlier in our class, we had a venomous discussion about whether the court should represent the differing perspectives in America by America's population. Is that something that you believe in? Is that something you can agree with, as there should be a representative of every of America on the bench?
Well, I would say, I think, yes. I think a healthy court is one where justices represent various points of view. I think it's fine to have, no, I don't really, but I do, some ultra-conservatives. But I would say that, and have always pushed the idea that we still need a Marshall or Brennan on the court, and we don't have a Marshall or Brennan. I think progressives have in this area, as well as many others, kind of settled or accepted the limitations of the current political reality. So I would say the current court is not balanced. We've got 4 ultra-conservative, hard-right justices. I mean, is there any question as to how Clarence Thomas is going to rule in the upcoming health care case or affirmative action case that they just agreed to yesterday, or the immigration case that's going to be argued soon, or the voting rights case? Not a question in the world as to how he's going to vote. That's not right. By the same token, you wouldn't want someone on the left who is merely, before you open your mouth, a reliable vote for your point of view. I don't think that's healthy for any side or for Americans. But I do say that you've got now on the court, you've got 4 hardline, conservatives, you've got 4 moderates, you've got Anthony Kennedy in the middle, who pretty much votes with the Republicans and appointees, and we're still looking for our Thurgood Marshall to be on the bench. I think it's important, what it brings you to, what do you really want in a judge? What makes a really good judge? And I think for me it comes down to someone who obviously has, an excellent analytical capability. 2, someone who's humble, who accepts really the importance of what she's doing on the court. And then 3, someone who understands the impact on everyday people that his or her decision will have. To me, that's what makes a really good judge, whether you're at a district court level or a court of appeals level. And so I would go to that standard, more than left, right, or, yeah.
I was just wondering what role you see the media playing in the judiciary process, and more specifically with what you do.
The media used to play a huge part and a huge role. Every newspaper used to have a legal affairs reporter. They'd have a Supreme Court reporter. The newspapers that I read, take the New York Times. There's no legal affairs reporter anymore. No one covers the court. Adam Liptak covers the Supreme Court, but no one covers these issues. The Washington Post used to have, any number of people who covered what the courts do and covered nominations. That doesn't exist. If we want to talk to people, we go to Huffington Post. We go to Talking Points Memo. We go to, we don't really go to Daily Kos. But we put our stuff out over the internet. That is our audience for the media. It is totally, totally different. I used to feel like I grew up with a whole bunch of reporters who covered the courts, who loved the courts. I used to say to David Savage, who is the Supreme Court reporter for the LA Times, I said, I can just see us in our 90s, in our wheelchairs at the assisted living home, debating the finer points of the Thomas nomination. Those reporters aren't there anymore. Most of them have left or leaving. It's totally changed. It's not to say that it's not covered, but it's covered so less in the mainstream press than it ever was.
You outlined a lot of the problems that you see. What
Yeah.
are some of your potential fixes?
Fixes. Okay. My fixes. Well, I should tell you, this is an idea that we're debating among ourselves, and that is term limits. I never thought I'd think about term limits. But actually, we are the only country in the world that has lifetime tenure. Interesting. I think Rhode Island is the only state in the country that has life tenure. And so wouldn't it actually be healthy to, I can't say where I am, and it still feels gimmicky, and I know term limits, to get term limits you'd need a constitutional amendment, which is not going to happen unless the left and the right rise up together, and it's probably not going to happen. So term limits is something we're talking about. There's lots of things I'd love to see differently with the confirmation process. I'd love, the next time we have a Supreme Court confirmation and we have a hearing at the Senate Judiciary Committee, I don't know about you, but I wince. I cover my ears. I go under the table listening to some of the questions that are asked by the senators. And it's not just Republican senators, it's the Democrats as well. I remember, I don't know, you guys won't, Paul Simon was a wonderful senator from Illinois. I remember him asking David Souter if he had ever, he was trying to get a sense from David Souter. David Souter's a man of few words, and he's very self-contained. And I remember him asking David Souter if he had ever spent the night in a tent outside. You know what he was getting at, but if you've ever watched a confirmation hearing, you're not listening to pearls of wisdom from anyone. I'd love each side to hire a lawyer who, after all the posturing is done by the Democrats and Republicans, could actually ask the question, some really important, penetrating, provocative questions of the nominee. Because, why do you laugh?
Because most of them are lawyers themselves.
What, the who? The
Judiciary.
you know, they are, but some aren't. Like Dianne Feinstein is not a lawyer. But nevertheless, let's put that aside. They can't ask a question to save themselves. And even if they ask a question, you know, if they have a sheet of paper, they don't know how to do the follow-up question because they don't really have an understanding of what they're trying to develop with a nominee. A staff has put together, a list of 20 questions. I'd love to see really smart lawyers for both sides ask the questions. The senators are just there for the TV cameras. The Supreme Court is the only time, when there's a confirmation, it's the only time that anyone pays attention to the court. It's the only time Nina Totenberg will really cover a story, and you get the other Supreme Court reporters doing their thing. And so it's a time when the country is really, well, I don't want to be that grandiose. A few people in the country are looking at C-SPAN and looking at the hearings. It's a great opportunity, I think, to talk about what the court does. It'd be really great to have a couple of really smart people managing those hearings. Yeah.
Regarding your statements on the media, and I'm Federalist Society president.
Congratulations.
I know someone was waiting for the emergence to come. Roosevelt's CourtPacking plan, World War II, post-World War II, and the pushback from Republicans there. It seems like historically, in the development of the Federalist Society as a response, and I don't know if it's been vilified in this presentation or not, I think it's matter of fact, but it's been a pushback from direct or indirect liberalization, a response to things that mainstream America doesn't necessarily always believe or feel, because America still identifies as kind of a center-right country and not a progressive left. In your presentation yesterday, all your news clips came from progressive MSNBC. And this thing here, everything is coming from the left. And I know your organization is a Soros-funded organization.
No, actually, it's not. God damn it.
Well, the open secrets has fingerprints.
Oh, in the past it was. You're absolutely correct.
Okay. So my response really to your assertions is Federalist Society and the Republican it's responsive. And Federalist Society was created to respond to the liberal academic education that a lot of students, four in particular, said, wait, this is not how we believe, this is not how we read the Federalist Papers, this is not what Madison intended, this is not, and now we've got a president who, while everyone was swooning during his election, said, I think the Constitution is a document of negative liberties. It was a flash in the face of more conservative people who have actually read the Constitution. I personally did not, I'm not a big supporter of him, surprisingly. But any response to that?
Well, I would say I showed a film for those of you who weren't here yesterday that put a spotlight on some of the ethical misconduct being carried on by some of the justices on the Supreme Court. And yes, namely Alito, Scalia, and Thomas, and the fact is we looked far and wide because we knew we'd be attacked, legitimately so, if we didn't really scrutinize the behavior of all 9 justices, which we did, and we couldn't come up with anything. We called ethics scholars, I don't mean to be defensive, but so this film, just to let some of you, it was about those 3 justices. Now you say why just the liberal media is featured. I would have died and gone to heaven for this movie if Fox News had ever covered this, right? I mean,
They were the
This-
only ones that covevered the Goodwin Liu
they.
thing so strongly, and they were.
But I'm just saying, had they covered this, had Fox News covered the ethical transgressions of these justices, and no one has quibbled with the facts in this film, I would have been more than delighted. So you had to only go with what you had, which are Jon Stewart and Stephen Colbert and Emma, you know the crowd. What to say about the Federal Society? I mean, look, the beauty of our profession and our world in our country is that there's room for everyone to play a part and play a role. And I disagree vehemently with the goals of the Federal Society. I only wish that historically, going back over time, that our Supreme Court had been, consistently, I don't want to say liberal, but advancing progress in America. I would say the Warren Court was a brief moment, fleeting moment in time. We have not seen a Warren Court in this country, and by far, this has been a pretty conservative court over the centuries and decades. So I would say that the Federal Society has its point of view. I have always believed that the point of view is one that would, in essence, turn the clock back on so much of the progress that's been made on women's rights, civil rights, consumer protections, and the like. But I think that, that is the great debate and discussion that pervades our thinking about the courts. And I'm hoping that we can develop an equally strong counter to the Federal Society so that we can have a robust debate that's honest. So I'm glad the Federal Society is there. Just don't agree with you, but you don't agree with me, so that's cool. My kids don't agree with me.
We are going to have to leave it
All
there because we're out
right.
of time.
Well, thank you
Please,
all
thank you.
very much.